All right, hello, and welcome to this evidence video capsule. And this is going to be a fun little capsule, and I do say little. And the reason it's going to be short is because even 10 years ago, this would have been a very complex capsule with a lot of issues surrounding competence and compellability. Luckily for all of us, these rules have been radically streamlined in the modern era, and the rules about witness competence are virtually irrelevant. Compellability still plays a factor, but nowadays understanding the rules is as simple as 1, 2, 3, so let's just jump right into it. So in our system of justice in Canada, we believe first and foremost that it is witnesses who should provide the bulk of the evidence. We certainly try to narrow the nature of disputes through admissions and sometimes use judicial notice to prove obvious things. And as I will show in another capsule, we obviously admit lots of documents and real evidence to prove things. But first and foremost, we want witnesses to come forward and testify about what they know. I like to say that witnesses are the gasoline of the trial engine. Without them, we can't really have an effective judicial system. So we need to be able to call them to volunteer to give evidence or force them to give evidence. And really, that's what competence and compellability is all about. And that's as good a place as any to start. A witness is competent if they are eligible to testify. A witness is compellable if they can be forced to testify. And both of these doctrines need to be understood within the context of a third. Sometimes you will have a witness who is competent and compellable, but holds nothing but privileged information. Think about it this way. Let's assume that the only relevant information they know is privileged. Can they testify? The answer is no. Are they competent? Sure, they're competent. They are eligible to testify because competence looks at their status as a witness. Can they be compelled to testify? Absolutely. They're in front of the courtroom. They can be forced to testify. But they have no material evidence to offer because everything they know is covered by privilege. So in other words, there are different reasons why a witness may not be able to give evidence or may not be able to be forced to give evidence. We don't call them all the same thing. For the purpose of this capsule, a witness is incompetent if they do not have the necessary prerequisites or status to testify. They are not compellable if they have that status, but for some policy reason, they cannot be forced to testify. And frankly, they are both competent and compellable, but have no relevant evidence to offer if everything they know is covered by privilege or immunity. And by the way, on this last point, one final matter. Obviously, if they have some things they can testify and some things they can't testify about, they're only allowed to resist matters that are covered by the privilege or immunity. So a witness who's holding such a privilege or immunity is very different from a witness who is not competent or compellable. Now, I said that in the old days, the rules of competence and compellability were very, very important, and the reason can be summed up in a nutshell. Competence used to be used as a way of screening out unreliable evidence. So, for example, at common law, accused persons were incompetent to testify, even on their own behalf. They couldn't testify for themselves. And the reason was because the common law said, well, they're interested parties. And interested parties are not likely to give reliable evidence, so we will kick them out. Those rules are gone, all of them. The competence rules, I won't even bore you with the details, have all been wiped away. We no longer treat unreliability as a reason to exclude a witness. We make it a question of weight. If you don't want to believe his evidence because he has an interest, that's fine. That is something for the jury or trier of fact to consider in weighing the witness's evidence. Johnny still has an important interest to protect, and that interest is the right against self-incrimination. You can't force Johnny to testify, and that's why today we respect that right in a more limited way. You cannot be compelled to testify against yourself, but you can volunteer to testify if you wish to do so. And that sort of shows you the difference between a competent witness, Johnny, and a non-compellable witness, also Johnny. He is non-compellable on behalf of the prosecution. So these days, competence really asks whether a witness has basic testimonial capacities, and that's really all it is. At common law, every witness had to have a very minimal capacity to do these four things. Okay? And I can tell you that under statutory law today, these requirements have been reduced even further. Nowadays, we respect these four things, but a lot less than we used to. The real issue arises when we're talking about young children who might not be able to perform these 4 tasks and mentally disabled adults. Those are really the only 2 categories of witness for which we need to worry about competence anymore. And today, even those requirements are very rarely contested and not that hard to meet, because the basic rule is we want these witnesses to testify if they can, and if they can, we'll let any weaknesses in their abilities to do these things go to waste. Remember, in the old days, it was the reverse. All the weaknesses went to admissibility. They would say to kids, well, you're not good enough as a witness to meet the minimum, so we're going to kick you out. Today, the entire philosophy is different. Bring the witnesses in, and let's hear what they have to say. Test their evidence as a matter of weight. And the governing statutory law makes that clear. We presume that young people have the capacity to testify. We don't even let them take an oath anymore, because there used to be a lot of kerfuffle about, well, they didn't understand what an oath was, so we're not going to let them testify. We also make it clear that when they promise to testify, we will let them do it as if they are taking it under oath. And the only real criteria is to show that they can understand and respond to questions. And again, all of this has been done to make it easier to bring witnesses in to the judicial process. And the law is not much different for witnesses who have problems with mental capacity. And I should stress, if you did have witnesses who had a really severe mental disability, a severe form of dementia or a severe form of progressive intellectual disability, you could definitely have them excluded as a witness, though frankly this doesn't arise very often, because it's got to be pretty extreme circumstances to want to call one of those witnesses. Effectively, they'd be the victim of an offense of some sort. But again, all of this is designed to make it simple. We want to be able to show, are you able to communicate the evidence? If you can't swear an oath because you don't understand what an oath is, no problem. Just promise to tell the truth. Again, all of this designed is really to get around the competence inquiry. We don't want this to screen out witnesses unless they are so problematic that we just have no choice. We can't put them before the judicial process. And that's really all there is to say about competence. The more interesting questions these days, and even these are pretty limited, have to do with compellability. And essentially, you can really boil it down to about 4 categories of witness for whom compellability can be a problem. I already told you about the accused. That's an absolute rule. You cannot compel the accused to testify against themselves in their own trial. The other one is a judge. You're not allowed to call the judge to testify about any aspect of their judicial capacity. I should point out that a judge is the same person as anybody else, just a person, and if a judge witnesses a bank robbery on their way to work one day, no problem. Call them as a witness. But judges cannot be called to explain some aspect of their judicial reasoning. We don't want that to happen. There's a bad policy behind that, including the idea that judicial independence needs to be preserved. So we don't allow it to happen. Ministers and politicians, very complex area that I'm not going to get into too much detail here. I may do a supplemental capsule on this down the road. But essentially, ministers and politicians are not immune from being called as witnesses either. However, they have a special form of immunity called parliamentary privilege that allows them to delay testifying. Okay? And I should say that in practice, courts are very skeptical about the ability to call ministers and politicians simply because they're wary of, the individual litigants trying to embarrass politicians and ministers. So that doesn't mean they won't be called, but the courts will look very carefully at whether or not it's necessary to call those witnesses. But again, the doctrine of parliamentary privilege is a form of immunity, and if the minister or politician fits into that parliamentary privilege, they can resist giving evidence. And the last one is the opposing lawyer in a case. Now again, lawyers are not immune from being called as witnesses either. But as you can imagine, calling an opposing lawyer to testify is a real tricky business, because essentially the courts don't like having lawyers act as witnesses at the same time. It puts them in a very bad position where they have to judge the credibility of the witness lawyer, and the lawyer is also, the agent for the party. So the courts really like to resist that. So the way in which they resist that is they don't let lawyers get called as witnesses. And essentially what happens is, if you want to call an opposing lawyer as a witness, you've got to show that it's absolutely essential. And if you can't do that, they won't allow you to call the witness. But if you can do that, they'll usually strike that lawyer as the lawyer of record, because now that lawyer is a witness. This is a little bit of a complicated area of law, but I can tell you that that's the basics of it. If a lawyer is going to be a witness on any type of controversial matter, they will no longer be allowed to represent the party in question. And if you can't show that it's really necessary to have them testify, you cannot compel them to testify as you would an ordinary witness. So keep in mind, problems of compellability are interesting ones. And as you can see, what binds them together is strong policy reasons why you should not be able to call this category of witness: judge, accused, minister, opposing lawyer. And that's all we're left with today in considering a huge slate of old rules that used to deal with competence and compellability. We're left with competence rules dealing with some very extreme types of witness, very young children, very mentally disabled adults, and a few problems of compellability. That's really all you need to know about basic questions involving witnesses. I hope this was of interest to you. Have a great day.
To learn more about this topic, you might want to check out my book, The Law of Witnesses and Evidence in Canada, published by Thomson Reuters. This book covers every topic involving the law of evidence and also how witnesses come before courts and tribunals in criminal, civil, and administrative proceedings. To learn more, you can check out my website at petersankoff.com.